What are those rules associated with the arbitration? Area practice and procedures, they are global in nature. Pakistan leads intertwine it and promote the attainment of such policies to improve the capability and the capacity to arbitrate and with the art practice act. So this is what the apparent theme of this panel is. But there is also an undeclared key, which is that arbitrate and not litigate act. So in Pakistan, currently we are having two different laws dealing with the foreign and domestic arbitration.
One is an Arbitration Act 1940, another is Recognition of Foreign Arbiter Awards Act (RAAA). But to start with both these, there is an underlying principle, which is that none of these statutory they actually oust the jurisdiction of our courts. Courts still retain the jurisdiction and deal with the matter. There are two issues coming
Today, one is a situation before an award and the other one is a post-award situation.
So let's dissect the foreign award and the domestic award. We have
Very aggressive, proactive enforcement with regard to foreign arbitration awards
after the promulgation of this Act of 2011. However, the main problem is the domestic arbitration. Because the law dealing with the domestic arbitration actually provides a lot of room for interference to the court before pre-arbitration stage and post-award stage. For instance,
that our courts are entitled to interfere in the matter of appointment and removal of an arbitrators. The court can actually revisit the awards
in exercise of power, because unless the board passes a decree on award, the award would never become a forcible document. So actually, our courts have the power also to modify a domestic award. So the problem is that once an award has been made by an arbitrator, it again goes to the court where almost a full trial is conducted of the case, then the decree is passed on that. And the time to view the entire process is minimum 5 to 6 years. So my focus today is that how to deal with this problem that should encourage the domestic award to be effective and enforceable. It's prejudicial. My experience is that unless we amend the Arbitration Act 1940 and actually create an environment where courts are actually supportive of an arbitral process, which the basic criterion that I puts, speaking from my experience, why the courts are not comfortable with referring a matter to an arbitrator, for the reason that we don't have a forum available which enjoys actually a credibility, capacity, capability to deal with the problem. So this perhaps is the biggest problem currently faced by the courts. And then the other issue is that the courts in Pakistan are just guiding their own jurisdictions. So convincing a court to refer the matter to an arbitration, and that too in the domestic cases, perhaps it's little difficult for the court, before staying the matter or referring it to arbiter, carried out a full appraisal of the case. So what actually has to deal with this is that how to deal with this scenario, and after all the speakers, we will conclude that what actually is a way forward.